in2 session. My name is Patrick McCann. I'm one of the three co-CEOs of City Century, the career creation collaboration that has worked with over 50 mainly London-based law firms, currently working with over 40 to bring in solicitor apprentices into London each year. We target somewhere around 130 that we offer to. We will be opening our next recruitment rounds through our law firms from about September, October of next year, and be making offers in the spring of next year for those people currently probably year 12 going to year 13 to start with us in September 2027. I'm really pleased that you have joined us for session 6 of our 10-module in2 series. Today's session is called What Work Do Lawyers Do? Just to place this in context, the reason we've put in2 together is because we know from government there is a real dearth of opportunity for school students to be exposed to work, either in the form of in-office work experience or virtual work experience. This is our response to that, following reports from the Careers and Enterprise Company. And what we have done is to create 10 modules, which get delivered on a Monday and a Wednesday in sequential order through June and July, finishing on the 8th of July. And the idea of those is that by the end of it, you will have had a really good exposure to what it's like, what work is like within the city, etc. Our sequence goes: what's London, what's the City of London, what business does the City of London do, what do the City of London law firms do, who works in law firms. Today's session about what do the lawyers in particular do, and then we will move on to what skills are required, what do the recruitment processes look like, how can you evidence those skills, and then how do you qualify as a solicitor. So thank you to those of you who are staying with us through the series. We've been really impressed by the number who are in, and thank you also for your sterling interactive engagement as we've gone through. We've been really pleased to see the sorts of questions we're getting, and they are increasing both in terms of quantity and in terms of quality. I'm going to hand you over to Finlay, who will introduce the solicitor apprentice with the best name, Orpheus Nikopoulos, who we just love because of who he is, but also obviously for his name, and his principal, his supervisor here today, Jamie Pollock. But first of all, I'm going to hand over to Finn. I will come off screen, but I will be in, and I'll come in and out as we pull, as we go through the session. Thank you so much. Break a leg, both of you. Team Hogan Lovells. Suck it to them. Thanks very much.
Thanks for that, Patrick. Evening, everyone. Thank you for joining us on what is a very, very hot day all over the country. So really, really appreciate your time and your commitment to the series so far. Just a couple of admin points. As always, feel free to get in touch with my email address if you've got any problems, which I know a few of you have. Big reminder as we come sort of to the second half of our series now on episode 6, to keep engaged. As we've said at the start of the series, you need 8 out of the 10 sessions of attendance in order to get your certificate that shows that you will have attended 8, 9 or 10 of the sessions so far. So if you've attended all the sessions so far, you only need to do 2 more. So that'll be next week, and then you will get your certificate saying 8 out of 10. So do you keep committed to those? And otherwise, any other admin points, please do get in touch with me, and keep an eye on our LinkedIn for updates of us posting some content about the webinars, and then we'll be keeping you in touch as well with when our next webinars will be. You've got the calendar with the schedule so far. Otherwise, all I've got to do is introduce you to Orpheus and Jamie. Thank you very much for joining us, and I'll pass over to you.
Welcome everyone. We are from Hogan Lovells, and today we will be taking you through this activity workshop on what work do lawyers do, and particularly what work do lawyers in a city law firm with an international reach do. We'll start off by introducing ourselves. So my name is Orpheus, and I am a first seat solicitor apprentice. My path into law was completing 6th form, taking some time off to go traveling, and then applying for a solicitor apprenticeship, and ended up here at Hogan Lovells. The team that I'm currently sat in is international trade and competition, which is where my supervisor Jamie sits. And on a day-to-day basis in international trade, we might deal with a range of things, ranging from financial and trade sanctions to sort of export controls, that might be military items, and other things such as customs and import measures. overall, this spans mainly the UK and the EU, but we do also work on other things such as the US.
And as Orpheus has said, I'm Jamie, Orpheus' supervisor, and we're sort of part of the overarching global regulatory kind of mass team here. But Orpheus has sort of become a bit of a specialist in an area that I'm not really a specialist in actually, which as he says, is trade. Whereas I do a bit more of my work is a bit more focused on competition law and on other related forms of economic regulation. So that's often looking at the way that our clients or other businesses that they are having problems with interact with markets. And sometimes that involves thinking about new regulatory systems or dealing with government public authorities. But basically, the kind of overall theme of the work that I focus on is to do with market dynamics and I suppose competition within markets. So that's us. Um,
Oh,
and then yeah, I think we were just going to start off, I think, talking about kind of the different roles that people can play in a law firm. And I suspect that some of this might be familiar to some of you, but maybe not all of you. And it's definitely worth us giving an account, I think, of the different kinds of people that work in a law firm. And so, yeah, as I say, some of this might be familiar. Like, I think obviously you probably know what a solicitor apprentice does, or maybe you don't, and that's why you're kind of paying so much attention to this series. But we've kind of in on this slide mapped out the different kinds of people who work in a firm. And I suppose there is a structure which traditionally has been seen as a bit of a hierarchical structure, but I think as in 2026, certainly at our firm, we try to kind of manage things with an open door, and everyone speaks to everyone, and everyone works with everyone. But basically, we have partners manage, I guess, partners and senior people like counsels and senior associates are probably involved in the kind of overall management of matters. And it's probably true that the counsel and partner roles are probably a bit more focused on winning work and developing practices, so forming relationships with the clients. But I would say that kind of everyone in the firm has that role as well. It's just that maybe at the senior end you do a bit more of that. And then the associates and senior associates are really responsible for kind of making things happen on matters. So managing the day-to-day conduct of a matter. And I would say that it's probably fair to say that they do that with the support of paralegals, solicitor apprentices, and trainee solicitors who they supervise. So I guess the thing that's distinct about the people in the junior bracket that we've got there is that all of those are people, well, to an extent, they are people who are kind of learning the trade, or they may have a kind of a sort of a role within the structure which is kind of supporting whilst they do some learning. Of course, I think paralegals are often very experienced, but certainly in the case of solicitor apprentices and trainees, they are there in a kind of a role to absorb information about how the team works, and then also to help deliver the work by carrying out a range of tasks. And I guess what's good about those roles is that they're probably better suited to do lots of to kind of they might spend a lot of time working on a matter, but their time is less expensive than an associate or a senior person. So whilst they will be able to they in lots of cases are actually able to do exactly the same kinds of work, and Orpheus is definitely someone who fits into this category, but they may do exactly the same kinds of work as an associate, but you would structure the matter differently around cost. And it's often the case that people at the junior end they often offer a more cost-effective way of delivering against a budget for a matter. And then it's important to also realize that at law firms, there are lots of people who are not carrying on the fee-earning legal role as such, but they support the fee earners, and there's a huge range of people. So on the business services side, there are the sort of people you would expect you'd get in lots of different kinds of businesses, not just law firms, but business development people who are there to assist I guess the more senior people to and junior people as well to an extent to project ideas about what the firm should be doing in terms of winning work. So that's the business development and marketing side. And they'll help you kind of if you want to do a LinkedIn post or if you want to talk at an event or set up an event where clients might turn up, then they might help you do that. And then you've also got, human resources and risk and IT support, and document production, who are people that help you produce paper documents and bundles for big court hearings. All of those people are kind of sort of essential to the functioning of the firm, as are the legal support people, so people in research services and knowledge lawyers who I guess are expert on answering questions and finding the right information to answer questions. And then also our PAs, TAs, and legal secretaries who are there to help with all manner of, I suppose, ranging from admin matters to life matters to helping set up events, billing, all of those sorts of things. And I guess what I would say is because, of course, the law firms are businesses, having people who are specialists in those areas is kind of essential to making sure the whole thing functions properly. Um, cool. I think that's kind of just a bit of an introduction to the way that we work and who we are and the way that our roles work within the bigger ecosystem. And I think Orpheus was going to maybe just talk us through the beginning of a kind of case study that we wanted to use to demonstrate the kinds of issues that he and I have been working on, at Hogan Lovells. And the purpose of this case study is it's not to sort of go into lots and lots of detail, but it's to give you a flavor of the kind of fact pattern that we're dealing with on a daily basis, um, and the sorts of issues that we as lawyers are being asked to advise on.
Yep. So as Jamie said, we will now predominantly look at a case study and sort of an interactive session, as we would like to receive as many answers from all of you as possible and try and not only tell you what city lawyers do, but rather try and have you think like a city lawyer and actually produce some ideas that city lawyers might have. So in front of us, what we have here is a hypothetical merger and acquisition deal. I did make up these names. They are completely fictional. So, and ultimately what the case is, it is our client, which is Aeroglide, wants to purchase Blue Skies. They want to acquire them. They want to take over their business. And so as lawyers, what we initially do when sort of an acquisition is brought to light, we will want to look into certain risks or certain considerations that might be of interest within the fact patterns as to what we might want to consider when we actually go to finalize a deal. Therefore, what we realistically think of in these fact patterns will be sort of the geographic matters, the revenues, and the general spread of business activities, particularly when we're dealing with sort of international companies as such. So what we would like you to do is to first of all take some time to read the fact pattern in front of you for both companies. But if you could try and jot down 2 or 3 potential risks or considerations that you think as lawyers might arise when we review these sort of fact patterns in an M&A deal. And to sort of help you categorize this, you might want to look at sort of 2 or 3 risks that arise legally, so legal risks, financial risks, and maybe other sorts of practical risks, such as operative risks or commercial risks that you might think could arise for our client, the buyer, in purchasing the target. So we will give you a few minutes to do that and jot that down, and then we will move on to giving some answers.
Just a reminder to use the Q&A function rather than the chat function for that. So if you want to go to the 3 dots in the bottom, click on the Q&A function, you can put your ideas in there. Thank you.
Just in terms of ideas, could we just, for 2 or 3 minutes, just jot them down and then we'll ask for them to be sent into the chat after. That's okay. So yeah. think that's enough time? Or Jamie?
Yeah.
Okay. So hopefully that's enough time for all of you to have just thought of a few things. We don't need to look at every single thing that exists. So what we will do now is we'll move on to a risk spotting exercise. So identifying certain risks that you might think arise from the facts. Overall, and just to put this sort of task into context, as we mentioned, there's been sort of an initial agreement that our buyer will be buying the target. And ultimately, when these sort of initial agreements come in place and before a finalized deal can be enacted, lawyers, usually on both sides, will conduct detailed assessments of the target and the transaction as a whole to identify relevant sort of issues and considerations. And this process is normally known as due diligence. And yeah, is ultimately one of the most integral parts of any sort of merger and acquisition, and pretty much every single law firm will do it. And yeah, as part of that process, certain legal risks, financial risks, and practical risks will amount. And yeah, it'd be nice now to sort of explore some of the ideas that you all came up with. And yeah, feel free to send them into the Q&A chat.
It's good. We got some thoughts.
Yeah. So actually, just to make this easier, could we start with maybe some legal risks? We'll take it one by one in the categories.
And what I would say maybe about the legal risk as well is to think about, we've obviously got a merger situation, so we'll be advising our client, um, which I suppose could be either of these businesses, but I think for the purpose of this scenario, I think we're assuming it's the
The buyer.
acquirer who's buying the target. So the UK company. I guess in that context, can you think of anything that's a specific kind of legal risk that's related to the merger itself? So obviously there are lots of other issues that our client might have, but here we're really just focusing on the decision to merge these two companies, and also remembering that Orpheus and I are a trade lawyer at the moment. I should say Orpheus is temporarily a trade lawyer because he won't be one next year. And then my focus is on kind of economic regulation and competition. So we could talk about lots of different kinds of legal risks, but probably those are the areas that we're likely to be a bit focused on.
Yep. So I see one here, different employment laws. Yes, that is a really good one. Um, Maybe some of you picked up, but our client, the buyer, likes to run sort of a tech-heavy business with less employees, whereas the target runs, I think it was almost double the headcount. So yes, I think upon a sort of an acquisition, there would most likely be sort of a change in that structure, and they could definitely be sort of employment restructuring and employment contracts, and therefore, yeah, employment laws will definitely be engaged to see sort of how that restructuring will engage. Another one from Charlotte is the target's ongoing dispute. Yes, again, this is a very important legal risk and one that we would definitely account for. I think it would be important to understand both where that dispute is at and where its development is heading. And a lot of times, sort of ongoing disputes will be accounted for in any sort of written agreement, in sort of like a safeguard or protection mechanism.
Yeah.
Any,
And
yeah,
and I should say on that as well, I mean, both actually, that employment law comment and the dispute risk comment, they're good because we will have to go through a process as lawyers where our corporate colleagues will run a sort of due diligence process. And part of that due diligence process is to try and understand, as you say, what are the legal risks that our client would face if it bought this business. And sometimes those might be hidden quite deep down in documents. And you might look through a due diligence room which has got hundreds of documents that are kind of explaining where the value in the company is, and you might find something that's, quite sort of um, requires a bit of attention, but is not obvious, and you sort of your job as a lawyer is to do that due diligence and to find where those risks sit. And in this case, it would be to try and, as Orpheus says, work out at what stage is this dispute, and if this dispute has got the potential to be a really big issue for the target, then obviously the buyer would want to be able to assess the potential value of that, and they might say, well, actually, if that dispute happens, it's going to cost the company, X million pounds to resolve the dispute. So why don't we lower the transaction price to reflect that legal risk? So yes, that's a good part of the process that you've described.
Yeah. To take one last one on legal risk, I see a very good one here, which is the link to Russian businesses. This is very important, and this is one that we would look at in detail. And yes, as mentioned in the case study, the target does have links to an investment company which is related to Russian businesses, and therefore, sort of part of the due diligence process, we would definitely be looking to screen not only the investment company, but to also screen who may be controlling or owning that investment company. And ultimately, in the end, would us completing this acquisition be providing funds or other economic resources to sanctioned persons which would otherwise go against prohibitions placed on them. So yes, that is definitely one very important one, and one that maybe my team would be sort of drafted into to help on the due diligence side. And then yeah, so we'll now move on. So we've got some ideas here. So yeah, I think most of these are sort of described. So yeah, ongoing dispute, employment. Another two that we sort of picked up on, maybe on the competition side, would be jurisdictional complexities. Maybe Jamie, if you wanted to sort of touch on that on the merger control
Yeah,
front.
so I guess the thing that some of you might be aware of, but others may not be, is we have a system of merger control in EU and in local competition jurisdictions. So what happens if two companies are merging is that in each country where there is some business happening, um, a competition authority may have certain rules which require the parties to the transaction to tell the competition authority that the deal is happening. So you might have heard of big when there's a big national, merger of, say, a supermarket, um, then everyone takes an interest in it and it becomes a sort of news story because people are thinking, oh, is competition is the price of food going to be impacted, or the availability of food in my area going to be impacted because two national supermarkets are merging, or so you may have heard about merger control in that context, but here we would have to work with our clients to understand what are the competition arguments we would have to put to certain competition authorities, and which competition authorities you have to deal with would be determined by the revenue of the companies that are merging in different countries. So I think we learned, or from the slide before, we know that this is a kind of UK company and a Turkish headquartered company, albeit with a Russian owner. But they've both got revenue across Europe. And I think what that means is they're airlines who fly planes all over Europe, and therefore they generate revenue from customers who might be flying from London to Madrid, or they might be flying from Munich to Ibiza, or whatever it is. But the point is that all of these places are revenue generating, which means that in Germany, in the UK, and in Spain, there is potential for the competition regulators there to be interested in this transaction, because when the merger happens, the competitive dynamics of the market could be impacted by there being, instead of two competing airlines, you're going to have one less airline in the market because you've got a merger situation. So you have to go and you have to talk to those competition authorities about what they're doing. And I think what was notable about the slide before is the revenues that were involved were quite significant. So I think we were talking about collectively, we're talking about, I think, billions of pounds. So there would also be a chance, since these are businesses that are likely to have some footprint in Europe, that not only may you have to engage kind of local competition authorities in Turkey, for example, you may often also have to make a filing to the European Commission. So effectively, you would prepare a detailed filing which would explain what the two companies do, why they are merging, and you would also be making some positive case as to why this isn't going to adversely or not going to harm competition. So I suppose it's a corporate transaction, but part of our job involves often doing a bit of kind of advocacy where you're effectively making a case. You're saying the competition authority, you don't need to worry about this merger because we've thought about it and here are all the good reasons why it's going to be actually good for the market, good for other businesses. It's going to improve the experience for customers who are going to have a great airline that's going to, have all of these specialist skills and capabilities that just that one airline before didn't have. So that's the sort of thing that we're thinking about when we're thinking about our corporate merger control practice and the advice that we would give. And I guess the more complicated and often the bigger the merger, the bigger that piece of work. And if you've got a big geographic international spread of revenues, then you may have to engage with lots of different competition authorities at the same time to address these competition issues. And I suppose also sometimes, and I guess this merger looks like the one where there could be competition issues. You may have a lot of explaining to do to the competition authorities to convince them that this is a good thing that's happening. And ultimately, if the competition authority disagrees with the parties, and it will listen to other competitors, so it might listen to other airlines here, or it might listen to air regulators or air traffic regulators or whatever to understand what the impact's going to be. Um, the impact would be assessed by the competition authorities, and they might conclude that actually this merger is not going to be good for competition, and they may say we're going to block the deal. So that's kind of, as advisors, what we're trying to do is guide the client through that process, which could take months, if not years, and get to a point at the end where they get their merger cleared or they get it through in a way that's suitable or acceptable to them. So that's where our competition corporate expertise would come in on this sort of deal.
Yep, very nice. Sort of moving on, we will try to get through the next two quite quickly. But could you now pop into the chat some sort of financial risks or considerations that stem from the facts that we read? Yep, Rafi, that's a really good point that you make. Yes, as we've seen, I think you're mentioning, yes, both the debt and the decline in revenues. These would be two things that we would definitely look at, both as risks and also as sort of considerations and opportunities to sort of negotiate maybe a better price. So the fall in revenues could definitely support later negotiations in the value of the target and trying to bring that down, whilst at the same time, this existing level of risk could be seen, this existing level of debt could be seen as a risk in terms of sort of how geared is this newly acquired business going to be? What is the liabilities going to be? How sort of what is the interest rates? What is being acquired? And ultimately, what is the financial burden that is being placed on us by this acquisition? But at the same time, this sort of high level of debt can also feed into the transaction price. So sort of this risk of taking on financial burden can ultimately become a negotiating tool for sort of us on the side of the buyer to negotiate a lower price, which might, of course, be within our sort of commercial interests. Yep, sort of Charlotte, sort of the same sort of ideas. I think as well it would be key to note, and we definitely would look at the reasons. And I think in the case study, it is sort of mentioned that this decline in revenue or these financial burdens, this financial debt has been attained through the expansion of the cargo services, and therefore sort of we, as the buyer, have sort of an already established cargo services business. So it may be also a process of internally looking at how could we post completion sort of deal with these issues and sort of allocate our resources and become ready prior to sort of completion on how we would manage these sort of issues. Any other sort of ideas? If not, we will come on to some ideas. So yeah, target debt. Another one which sort of links to this ongoing dispute, and I think Jamie sort of touched upon it earlier, is the outcome of the dispute and also the ongoing sort of disputes can go on for years. So if it's a long-term dispute, that obviously comes with legal fees and other things that the buyer is sort of adverse to the buyer. So we'd have to look at A, what are the ongoing legal fees for that dispute? And two, what could the outcomes be financially if we sort of lose that case? Could there be sort of compensation paid? Could there be sort of fines to a regulator? And in general, what could be the financial burden from that? Other things that we obviously spoke about are the failing revenues, and then sort of other things that we might look at more or less in terms of integration could be sort of the integration cost. As we mentioned, as I think seen in the facts, the buyer and the target operate sort of different IT and booking systems. So therefore, is there an integration cost of getting those on the same platform? I think although both operate in Europe, they have hubs in different places in Europe. So what is sort of the integration costs in allocating offices? Again, both are headquartered in different places. So are we going to be headquartered in the UK now, or are we going to be headquartered in both? Are we going to relocate to a different headquarters? So sort of all of these integration ideas will obviously bear a cost. And then one thing which is particularly the job of lawyers during due diligence is trying to find things called hidden liabilities. So ultimately, what could the target not be showing us, or what could be a little bit more discreet that could ultimately have a financial burden on us, whether that is sort of where is the target in terms of its partner contracts? Where are they in terms of their logistics partners? Is there any sort of liabilities that haven't arose yet but could be arising soon and necessarily could be trying to pass that on without us necessarily knowing from the outset? And therefore, these are sort of hidden liabilities that we may have detriments to us post completion, and therefore we would want to try and identify them prior to any sort of deal going through. And sort of, yeah, moving on to the last category which we have, which is practical risks. And for this sort of task or risk spotting exercise, if you guys could think very broad, so think not financial, not legal, just think these two businesses coming together, what could be some sort of practical and operative risks that would come based on the facts, but in general, in terms of two big international companies merging together? Language barrier, yes. I mean, this would definitely be a case, of course. Um, as mentioned, they operate through both Europe and Asia, so language barriers can definitely cause complexities. Yes, different business structures. I think, as we sort of mentioned a bit earlier, there's sort of differences in traditional workplace versus tech. So these sort of things can have issues, potential lack of communication. Yep. Yes, this is a good one. Conflict between merging groups of people. A lot of the time, this may be conflicts between management, senior management. There may be sort of different ideologies that may be at the top of both managements, but this ultimately might be dealt with who stays on as a manager, or whether this would be a combination of management groups, or whether the acquirer or the buyer may
Yeah.
ultimately pass over what their management already exists.
And I think that that's a good example of one where it's quite easy to see how a practical risk also becomes a financial and a legal risk, because obviously if you're gonna if the employers if the owners of the business want to reduce the number of people in the workforce, they want to make the whole thing work, have a smaller group that's kind of operating, which is that's almost an inevitability when a merger happens. Um, will they, how are they going to do that legally? Because everyone has rights as employees. So you might be looking at having to think about like what's the legal risk associated with making that change, and financially, what's it going to cost for us to do that? Um, I guess the other thing to say, and I think the reference to business culture is a good one, which is you've got to think about how this is all going to work together, particularly if they are a business that's been headquartered in different countries, like the example suggests in Turkey and the UK. Then there is some work to do to kind of bring together those different, inevitably different working cultures. Um, I think the one, an anonymous attendee has written overlapping route of the flights, which I actually think is a really good comment. Um, the the um, the the point I was making earlier about antitrust and competition and merger control is that your incentive, if you're merging two companies, is to, I suppose, to gobble up as much market share as possible. So on those routes that I was discussing, so I think I said like Munich to Ibiza and London to Paris or something like that. If the airlines if in those markets, if that's how the markets are defined, the competition regulators will be interested in what does it mean in terms of customers' availability of options if they want to fly from London to Madrid, let's say. If before they had the choice of five airlines, but now they've only got four airlines because the two businesses that are merging used to compete with each other. So they were number one and five in the market for flights from London to Madrid, and now you've got four. Well, that's obviously the incentive for the business is that that's great because it means we've got one less competitor, and maybe it means that we can we know we're going to get certain kinds of customers. We might even be able to put up our prices because we've got fewer competitors. So the incentive in terms of the practical risks, the incentive is that on the part of the companies is to have overlapping routes so they can consolidate their market share. But that becomes a legal risk, I suppose, because in terms of convincing a competition authority that the merger should happen, you might need to explain to them why the merger won't be bad for competition in terms of the market for flights from London to Munich or whatever the destination is. So yeah, all really good comments.
Yep. So just looking at what we have, I think most things were covered. Sort of, yep. These sort of workforce culture differences. I think IT integration we spoke about previously, route overlap, and also one that we sort of picked up on as well was this sort of third party reliance. As mentioned, sort of the target heavily relies upon its sort of logistics partners and aircraft lessors, leasing companies and arrangements. So it would definitely be important for us to look at where those agreements stand, where the contracts are at, are the contracts expiring, or have the contracts got clauses that might be impacted by the target being acquired. And most importantly, in terms of the current ongoing legal dispute that we have, it might be important to see how that may impact the other agreements that are in place if they are to stay in place after the acquisition. So this we've sort of included and spoke about already, so we won't touch upon that. But in general, a point that we wanted to sort of cover is that all of these risks and considerations will generally be managed throughout the deal and within the final sort of written contract or contracts. Often or not, risks will be managed through protections, conditions, and safeguards. So on sort of the trade side of things, what this might include is any sale of the company um, which includes a sanctioned party. Often on cases, this will be if the sanctioned party is a minority shareholder. It might include clauses that say that that minority shareholder is to not be able to access any consideration or payment that arises from this deal. At the same time, it might also be on more extreme ends. As such, there might be termination rights that could come if any material risks arise on the sanctions side of things. So it's always good to bear in mind how these risks look, but then also how can we implement them within sort of the contracts and the main agreement itself later on to make sure that us as the buyer are sort of covered on all ends. So now we will have a look at past the due diligence process. So now we will look at sort of actually getting this final agreement in a contract and finalizing deals, negotiating all of these terms and looking at all of these risks and trying to actually acquire the target. And we will try and sort of frame this into different tasks that may arise and also how different people around the firm could engage within these certain tasks. So as sort of mentioned, and often or not in M&A deals, the sort of finalized deal will come in the form of a share purchase agreement. So it's sort of the main contract that deals with the pricing, the share price, the when the deal will come in, sort of the conditions, and we'll also address sort of these risks and sort of warranties or promises as to how things actually are often made by the target. And sort of within facilitating this deal, there are a number of tasks that, sort of occur as sort of listed out here, and these include sort of drafting, reviewing, negotiating, and researching. And importantly, sort of as Jamie will explain now in a second, these tasks will span across all levels of fee earners and will often be supported by non-fee earning teams. So just because, it may seem on the forefront that you're dealing with a very important document, a document that is, dealing with businesses that are making revenues in the billions, it doesn't mean that these tasks are only dealt with at sort of the higher senior levels of individuals, i.e., your partners or your counsel, but rather they will all seep through and there will be some sort of involvement throughout the whole firm, which Jamie will touch upon now.
Yeah, so I think as I was saying before, obviously there's a bit of a structure to the way that we staff matters and deal with things in a law firm. But what I would say as well is that everyone, for all of these tasks, really, everyone has a role, and that includes non-fee earning team members as well as all fee earners. So I think it's probably worth we could I think for the purposes of this audience and for you guys, the thing we really want to talk about is what does solicitor apprentices do and maybe what trainees do. Um, but on these four kind of processes, I would say that the what might happen is that the partner or an associate may identify a piece of work that needs to be done. So let's imagine on researching, let's imagine that there is you're involved in litigating a dispute. Um, and what you need to do is you need to produce a pleading, a legal pleading. And a legal pleading is like the argument. So it's like your claim for your particulars of claim or your defense. And it's effectively a sort of court document that describes uh, what your case is and what your argument is. And that pulls together factual evidence, it pulls together legal argument. And it's a really important document because it's going to record in front of the judge and the court, and it could be spoken about in public. It's going to record your client's position on its case. Um, and I think that's an example of the sort of document where the drafting is really important. Um, but the stuff that's fed into the drafting, so the facts and the legal research, you can very well imagine that a senior person like a senior associate or a counsel or a partner may come along to a solicitor apprentice or a trainee and say something like, "Well, I need someone to look at a load of documents to try and work out what a member of staff said about a particular issue on the 24th of June 2026. And when you look at that issue, I also want you to think about how that applies to the law. So, can you also look at this specialist case to tell me what it says? And I think basically a trainee or a solicitor apprentice, it's very much in the realms of possibility that they would be asked to go away, look for the right documents to check the documents, and then to find the case. And I think probably the way that it would maybe work within the firm is the someone at that junior end, so a solicitor apprentice, may do the first job of finding the document and putting it together. And then what you might find is that they would then have a conversation with a senior person, so perhaps an associate or a senior associate. And what they would do is that they would discuss the issue together, and maybe the associate or the senior associate said, "Oh, that's actually not the sort of document I was quite looking for," or "Thanks for looking at that case, but I think actually it refers to some other cases, and I think they might maybe more relevant." What then would happen is the solicitor apprentice or the trainee might then go back and have another go at looking for some more documents or looking at the new cases. And that task would therefore be a kind of iterative one, so whereby you're working together to try and improve on your knowledge of the cases or your knowledge of the facts. And then maybe when you've got an answer, I think what then would happen is the associate or senior associate might say, okay, we've got an answer here. I think we know what the answer is in terms of the facts and the law. So why don't we have a go at applying the facts to the law and let's draft a paragraph that's going to go in the legal document that's going to explain our case. It's going to set out our case. And I suspect that then what might happen is maybe the senior associate would do that drafting, but they may ask the solicitor apprentice or the trainee to check that drafting to see, do you agree with that drafting? And actually, if you don't agree with that drafting based on what you did when you looked at the facts, why don't you, why don't you look for, why don't you check that and then you could perfect the drafting? And I think what I've done here is I've spoken about a litigation context, but that all of that could equally apply to the example that's expressed on this slide, which is a share purchase agreement. So in a corporate context of this deal, so facilitating the deal, you might have we spoke before about due diligence or checking the law around how the mergers regime works, or in Orpheus's case, understanding how the sanctions regime works. The trainee or solicitor apprentice may need to go and look for the different products or the product codes and then match it to the sanctions regime. And they would have a go at pooling together the facts. And then they would go to a more senior person, like a senior associate, and they'd say, okay, I think we need the drafting in the share purchase agreement should say something like this, or the schedule needs to have all of this information in. And they would work together with the solicitor apprentice doing that first round of gathering the information. So in a way, actually, the form of the work and the processes that are involved is quite sort of there is common features to it across the different practice areas. So as we say, we've been speaking about doing a deal, but in litigation or in other forms of advice, it's often people at the more junior end who are doing the kind of gathering together of the information, the gathering of the facts, and then working together with more senior people to apply those facts to produce some work product. And I think just to sort of finish my bit, you get to a place where what the associate and what that group of people has done is they have produced a kind of client-ready work product. So in the examples that been speaking about, drafting in a share purchase agreement, or it could be drafting or producing a legal document like a pleading, like a defense in a case, or it could be drafting a note of advice. And then once you've got that client-ready product, typically what happens is you then present it to a senior person like a partner, and that partner will take a smaller amount of time, but will look at it and say, actually, this works legally and it's giving the client what the client needs. So I'm going to maybe I'll make some adjustments to it, or I think it'd be better if it was set out in that way. Or, your share purchase agreement, you've got the schedule here, but why don't we change that term or condition there? Because it will be more favorable for our client. But the thing they are reviewing is the thing that's been produced in this iterative process in collaboration between associates, senior associates, solicitor apprentices, and trainees. And I think that what I haven't done there is I haven't really spoken about the non-fee earning teams, like the support lawyers and the know-how lawyers and the PAs and everyone that works to support that process. But that there is something I think common about that process, and that's kind of how law firms work, which is it's a collaborative exercise where at the end you're producing something that's client ready, but you start from the base of gathering together the facts.
Yep, very good. Conscious of the time, so we will now move on and hopefully show some examples of where a solicitor apprentice has actually contributed to a piece of work. So the example we have here is similar, but not sort of the same to an SPA. It is a scheme of arrangement, which typically, just in a very brief uh, summary, is sort of the type of document you may see in a public M&A or otherwise known as a takeover, where sort of it's a sort of formal booklet sent to shareholders, proposing sort of the terms and the sort of conditions. And normally how it operates is this will go to the court and the court will approve the process if a certain amount of shareholders approve. And therefore, this is a way in which companies often can buy publicly traded companies off of the market and delist them and buy all of their shares without having to sort of negotiate or deal with every single party or shareholder that is to that company. And sort of similar to how we would see for an SPA, this process on sort of a on a sanctions perspective, and particularly dealing with sort of these public companies that have a number of different shareholders, often having small shareholdings or larger shareholdings, there might, of course, be a shareholder who is linked to sort of sanctions, who this may be they are sanctioned themselves or they're owned and controlled by a sanctioned sort of company or a person. And therefore, what we would be looking at is by completing sort of this acquisition, are we potentially in breach or would we be in breach of sanctions, whether that's in the UK or EU? Because we would ultimately be making resources or funds available, paying this shareholder to buy their shares of them. And therefore, in situations like this, as you see on the left, we will tend to put sort of provisions in which will say what will happen if this goes through and there is a sanctioned entity. So, what will it mean for the shares that that sanctioned person or entity holds within the company that we are buying, and what will happen how on us acquiring those shares will we aim to comply with the ultimate reason and why sanctions exist. So as seen on the left, this might sort of basically be reducing any sort of action that they can have. This might be, of course, giving no title or not allowing them to vote, or as mentioned previously, this might also be not providing them or withholding their funds until they are sort of sanction cleared, or in other cases, sort of maybe this Russia conflict dies down and the sanctions regime is sort of lifted. And to sort of look on how a solicitor apprentice, in this case myself, may have contributed to this. On the left, of course, we have sort of a drafted document, but on the right, we have the sanctions screening exercise. So this would basically engage in, we have an entity. So number one, we have this entity, and we will have to look at not only is this entity sanctioned, which in this case it wasn't, but who owns that entity, and then who owns that entity, and ultimately who is the global owner? Where does the ownership structure reach? Who controls the entity that controls the entity that controls the entity that controls them? And we would then look at this from a sanctions perspective and aggregate it all together to see whether the actual entity that holds the shares as part of the target may be linked to sort of a sanctioned person, which would flag a concern of us potentially breaching sanctions if we were to buy their shares of them. So what this process sort of engages with is looking at a bunch of resources, looking at a bunch of legislation, and trying to piece and looking at a bunch of corporate reports to try and understand, one, what is sort of the ownership and control structure, two, what is the exposure, and then ultimately doing an analysis of how is this aggregated and what sort of exposure is the ultimate shareholder that we are trying to buy off of being a sanctioned person or a sanctioned related entity, and therefore what do we need to put into the contract? What companies or what shareholders do we need to list as these potentially sanctioned shareholders that we would need to sort of address prior to completion of any sort of deal? And yeah, so this is a good example of where something an apprentice could do on the right, which might be sent in a sort of an email format, would then translate or sort of help within something that is on the left, which may not be shown in this example, but it may be in a schedule of this same arrangement, which would identify what this potentially sanctioned shareholder could be.
And
And yeah, do you want to
and then shall I move
Yeah,
on just to do my last bit as well, which is to say there's something similar about both these exercises, which I think follows on from what I was saying before, which is they're kind of preliminary or they're the first level of gathering facts in some respects. And this is another exercise that we've had solicitor apprentice help on, which is looking at disputes cases and investigations, sorry, I should say, looking at CMA investigations that are to do with competition law issues and recording them in a table so that we can have a look at the kinds of things that could come up in competition law investigations in the future. And so we get our solicitor apprentices to look around and to gather that information, which is all public information, and to find out a bit more about the investigation so that we can kind of think about is this something that's going to impact our clients, or is it something we need to be, we're just aware of for legal know-how for legal know-how purposes. Yeah.
yeah, I think that comes to the end. I don't think we have any time for any more questions. I think we're at 6 o'clock now. Yeah.
Well, first, Jamie, thank you so much. I think we might have time for people to put questions into the Q&A if that's okay. We started a little bit late, so and that was just a real masterclass in terms of showing how deals actually get done, how mergers and acquisitions happen, how competition is brought in, and for me, I thought was great is that it's clear that in that wide team that's involved, solicitor apprentices play a critical and important part and just form part of the whole. So I'm very grateful for you for that and that naughty Russian company. Need to be careful about that. And then the one that and let's make sure we have lots of flight lines so we don't all pay loads of money when we go on holiday. Finn, is it worth me just offering to the attendees who are on the line, if you do have any questions, and thank you so much for staying with us, please do put them in the Q&A now, and we'll answer them for the next couple of minutes if we may.
Yeah, 5 minutes or so. If you've got any questions, we have got a couple of minutes. So if you want to put those in the Q&A, massive thanks to both Jamie and Opheus. Brilliant session. Thanks so much for your time.
Thanks.
Just going to wait another minute or so just to see. It looks like people are beginning to depart. I just want to give them the option just because they won't often online. Just in case. Here we go. We've got one here. At what point would a solicitor apprentice be expected to produce the type of work you're showing? Would that be from the beginning or be expected slightly later? Thanks, Jamie.
Yeah, so to answer that, I think we actually showed two good examples for this exact question. So the second one, which Jamie covered, would be, and I think was one of the first things I'd done when I joined the firm. So that might be something you start off doing, which sort of doesn't go to a client, so there's a lot less risk that goes within it, and it's maybe sort of more on that business development side of things. Whereas the second sort of sanctions analysis thing was definitely something that progresses over time. Sort of the first time you do it, you might be heavily supervised and sort of looking over your shoulder and asking a lot of questions. Whereas sort of now coming into sort of a year, I sort of just get emails which give me one line entity name and I do the rest from there. But it's definitely the first one would not be something you'd see to do at the start, but definitely as you progress and you get a better understanding of what all of these terms and what sanction means and how all the ownership and control stuff make an influence, will you be allowed to go off and sort of do your own analysis and be trusted to do that?
Thank you, Opheus. We've got another question, Jenny. Maybe this one's for you.
Yeah.
What does Hogan Lovells look for when recruiting apprentices?
That's a good question.
Have amazing names? That's my main question.
Sorry, what was the last one you said?
Do they all have to have amazing names? Is that where you?
We do have a track record of people with amazing names, but that's not a criteria for selection at all. I think that's completely random, to be honest. I think the answer to that is a lot of it comes down to people. I guess you want to work with someone who you feel like you can get on with, and you want to work with someone who is displaying some good human skills, and they are a good listener. They are someone who wants to learn, who is enthusiastic, but is someone who is enthusiastic without being, I suppose, directive too much. Because I guess what I would say about this, the thing that's kind of particularly magical about this solicitor apprentice role is that you have had very little legal experience at all. In fact, in most cases, kind of zero legal experience. And that is actually that's a blessing because it means that you're in a position to absorb. And I think the people that we have found have done the best in the kind of interview process are people who have shown a genuine curiosity about the career and an interest in our firm, but what they've done so in a way which has meant that we felt they've understood that they're here to learn and they're here to be enthusiastic learners, and that they haven't come in with too much of a sort of clear idea about what they want to do, but with an open mind. So I think basically what I would say is solicitor apprentices, you should come at it knowing the limitations of your kind of legal skills, but enthusiastic about developing them. And it's a role that we in our firm really love. And so I think that's a positive story, but it's to be kind of both aware of your own limitations and therefore really enthusiastic about being a big learner.
Brilliant. Jamie, go first. Thank you so much. Unless there are any other questions, Finney, you're right to close the session.
Yeah, thank you, Patrick. Yeah, massive thank you to the Hogan Lovells team. Thanks so much for such an engaging session. I think a lot of the questions that we've had in the earlier side of the sessions have been really about, what's the kind of day-to-day look like? What kind of work am I going to be working on? So that's something that's really been covered in this session. So hopefully now you've got a really clear idea about the kind of roles, the kind of tasks that would be assigned to you if you're a solicitor apprentice, and then all the way through your career as well. Our next session will take place at the same time, 5 o'clock kickoff on Monday. So please do tune into that. We are at episode 6. That will be episode 7 then on Monday. So you're closing in on that certificate. Otherwise, in the meantime, if you've got any questions over the next couple of days before we get to that session, please do feel free to drop me a message to my email, which I know a few of you have, and I'll respond to you as soon as I get that. Otherwise, massive thank you to Hogan Lovells, and hope you have a good evening. Thank you very much.
Thanks very much. Jamie, you're
Thank
first. Just hang on just for 2 seconds. And
Sure,
thank you for
yeah.
the emojis that are coming up as well. I'm going to put my reaction in. There we go. Clap. There you go.
Thank you very much. Love a clap.
Oh, and you've even had a confetti cannon, which is